And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
When the police show up outside your home because a neighbor is worried or an ex-partner has a bad feeling, should they be allowed to smash through your front door? Should they be able to search your private space simply because you don't answer a knock? This was the horrifying reality for countless Americans under a dangerous legal loophole called the Community Caretaking doctrine. But today, the Supreme Court shut that loophole down. In a unanimous 9-0 decision, every single justice, from Clarence Thomas to Ketanji Brown Jackson, agreed on a single opinion that fundamentally reshapes the Fourth Amendment. The court ruled that the community caretaking exception to the warrant requirement does not apply to private residences. The unity here is stunning. The Supreme Court achieves 9-0 decisions in only about 30% of cases. And when the issue is searches and seizures under the Fourth Amendment, that number drops below 15%. That they all came together to forge a single, powerful standard tells you exactly how vital this ruling is. To understand why this is a true constitutional moment, you have to know how police departments were exploiting the system. For the last decade, law enforcement agencies relied on the community caretaking doctrine to justify warrantless entries into homes. This doctrine was never meant for residences. It was originally created decades ago to apply to vehicles, cars broken down on the side of the road, or cars involved in accidents. It allowed police to act as community caretakers in public spaces. But data shows the misuse was staggering. Warrantless home entries based on these vague claims skyrocketed by over 300% between 2015 and 2023. This created a blank check, allowing the government to bypass the entire concept of a warrant. Here's how that played out in the real world. A family member calls the police and says their brother sounds depressed. Police arrive. They knock. Nobody answers. Perhaps you're sleeping. Perhaps you're at work. Or perhaps you simply do not want to talk to the police. Under the old system in 15 states, police could cite the community caretaking function and enter your home anyway, claiming they were checking on your well-being. Once inside, anything they found, whether it was legally owned firearms, controlled substances, or evidence of a nonviolent state crime, could be used to charge you. In fact, in one Montana case last year, officers entered a home because of depression concerns, seized legally owned firearms, and used a state red flag law to justify the confiscation. The Supreme Court just put severe limits on this practice. But they didn't just limit the doctrine, they rejected it completely as a basis for entering homes. The case that brought this issue to the highest court involves a man named Trevor Cassis from Montana. The facts of his ordeal sound like a nightmare. Late one night, Cassis's ex-girlfriend called the police. Her claims were vague, shifting, and contradictory. Maybe she heard a gun. Maybe he threatened himself. Maybe he threatened officers. She couldn't remember exactly, but she just had a bad feeling. 4 officers responded to Cassis's home. They spent 40 agonizing minutes outside. They knocked, called his name, and shone flashlights through the windows. They observed an empty gun holster on a table inside. Getting no response, the officers entered through the unlocked front door under the community caretaking claim. They found Cassis upstairs in a closet. One officer claimed they saw a dark object, which could have been a phone, a wallet, literally anything, and shot Trevor Cassis. Cassis survived, but he was then charged with multiple crimes based on evidence, including a gun found in a laundry basket, discovered during that warrantless entry. This case highlighted the absolute chaos in the American legal system. Before today, courts across the country were using 3 different standards to decide when police could enter homes in an emergency. Your Fourth Amendment rights literally depended on which state you happened to live in. Standard number 1 was probable cause, the highest bar, requiring solid evidence that a crime was occurring or imminent. Standard number 2 was reasonable suspicion, a lower bar requiring specific facts, suggesting something was wrong. Standard number 3 was the community caretaking doctrine, the lowest bar of all, requiring only a vague concern for welfare. The Supreme Court decided they wouldn't choose any of those. They created a 4th path, an entirely new standard that now applies nationwide. Every American needs to understand this new constitutional standard. The court established what they call the objectively reasonable basis test. This test dictates that police can enter a home without a warrant only if they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. Notice those specific limiting words: seriously injured and imminently threatened. This is crucial. It's not enough to think something might be wrong. It's not enough to have a bad feeling. This new standard demands concrete, articulable facts that would lead any reasonable officer in that position, not the specific officer involved, but any hypothetical reasonable officer, to believe someone is facing serious, immediate harm. The court outlined factors to consider. Was the report of danger credible? Who made the report? Did officers observe anything concerning upon arrival, like blood or broken glass? Legal analysts suggest the new test is stricter than the old reasonable suspicion standard, but slightly more flexible than probable cause. It sits right in the middle, which is exactly what the court intended. But here's the twist that has constitutional law professors debating right now. Even though the Supreme Court rejected Montana's legal analysis and ruled that the state used the wrong legal test, they still ruled against Trevor Cassis. The court found that Montana erred in relying on the community caretaking doctrine, but when they applied the correct test, the new objectively reasonable basis standard, the officer's entry was still constitutional. The justices pointed to 5 specific facts that, when taken together, supported the entry. First, the ex-girlfriend's call detailing threats of self-harm and threats against officers. Second, the officer's prior knowledge of Cassis's mental health history. Third, the observation of an empty gun holster through the window, suggesting a firearm was present. Fourth, the 40 minutes of absolute silence despite repeated attempts at contact. The court argued that these factors, aggregated, made it objectively reasonable for the officer to believe Cassis might be inside, possibly injured, possibly suicidal, or possibly preparing violence. Many legal experts are already criticizing this application, pointing out that Cassis was under zero obligation to answer his door. This was a 9-0 ruling, so there was no dissent. However, several justices wrote separate concurring opinions, signaling they might have deep concerns about how broadly this standard could be applied in future cases. It creates a tension. If you are home alone, late at night, and choose not to answer a knock, has the court just created a pathway for warranted entry? This new standard immediately throws hundreds of pending cases into upheaval. I mentioned there are over 340 similar cases awaiting resolution in federal and state courts nationwide. Every single one of those cases will now be analyzed under the objectively reasonable basis test ein hoc. Cases where police entered homes based purely on vague community caretaking claims are now vulnerable and likely to be thrown out. Cases where officers had solid, articulable facts suggesting imminent, serious harm will likely be upheld. State prosecutors are scrambling to figure out which convictions will survive. The National Center for State Courts estimates nearly 3. 0 cases currently in state appellate courts involving warrantless entries must now be re-examined. But there is one category of case this decision affects that nobody is talking about yet. What this ruling means for red flag laws is profound. 21 states currently have red flag laws that allow law enforcement to temporarily confiscate firearms from people deemed a danger to themselves or others. The enforcement of these laws often begins with police conducting a welfare check, entering a home without a warrant, and then using what they observe to petition for firearm removal. Today's ruling just made that process significantly more difficult. Many of those initial welfare check entries relied on the low bar of community caretaking. Now, officers must meet the objectively reasonable basis standard. If the only reason police enter is because a family member reported depression after a breakup, and the resident isn't answering the door, that entry likely does not meet the new requirement of imminent serious harm. If the entry fails the test, any evidence seized, including the firearms observed, cannot be used to justify the red flag petition. Statistics show that 37% of red flag petitions originated from police-initiated welfare checks, where officers entered homes and observed firearms. If a significant portion of those entries now fail the new standard, those petitions could be challenged and struck down. So, let's get practical. What does this ruling mean for your rights starting today? First, if police show up at your door and you don't want to talk to them, you do not have to answer. The simple fact that you do not respond to knocking is not, by itself, enough to justify entry. This is a crucial clarification. Second, if someone calls in a welfare check on you, an ex, a neighbor, a family member, police cannot just automatically enter your home. They need objective, articulable reasons to believe you are facing serious and imminent harm. A vague bad feeling is simply not sufficient anymore. Third, the mere presence of legally owned firearms in your home, even if visible through a window, is not grounds for warrantless entry. The court recognized that millions of Americans legally own guns, and that ownership alone does not create an emergency. However, if there are multiple factors present, a credible threat of self-harm combined with non-response, and the visual confirmation of a weapon, those aggregate factors might still meet the objectively reasonable basis test, as they did in Cassis's situation. This ruling doesn't affect other warrant exceptions, like hot pursuit or evidence destruction. Did the court strike the correct balance between protecting your privacy and allowing police to respond to genuine life-threatening emergencies? Or did they make it harder for law enforcement to save lives? Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I will see you in the next one.